Gentlemen, welcome to ABS channel 88.9 FM Oka. Today, the weather looks like a heavy rain is coming. So far, traffic is moving in all sides of the city, but never forget to move with your umbrella. Today in the news, the police has increased its clampdown on Yahoo boys in the state, as the new commissioner of police, Musa Muhammad, in his speech last night, promised to rid the state of all kinds of nuisance and mischief makers. The commissioner...
Okay. Who is there? Who are you? Excuse you. Who are you?
Well, you must be Mr. Tom T.
Exactly, I am.
Okay. My name is Inspector Sam from State CID, Oka.
Okay, why are you here?
And here with me are some of my officers. There was a petition brought against you at the command, and we're here to invite you over to come with us.
What for?
When we get there, we would explain everything in details.
All right. Can I get my lawyer on phone?
You could come with us, then when we get there, you call him, he can join us.
What's the reason for the arrest? Excuse you. You can't just barge into my house and you're trying to pull me over there. It's not really necessary.
Mr. Tom.
Excuse you.
I would say this. Whatever you say or do here will be used against you as evidence in the court of law.
Oh, really?
Yeah.
But do you know you have some people that camouflage as a police to come and arrest people in their home right now?
You just saw my ID card,
Excuse you.
Please.
You can fake your ID card for any reason.
You can do your job.
Excuse you. Please don't touch me.
Don't let my officers...
Excuse me. I said don't touch me, guys. I'm going to go on my own. Excuse you. What rubbish. The crew to calls on any cafade. So stupid. I want to arrest somebody in this house. Nonsense.
Officer! I beg we raise you.
See, if I come that place on a day, what I go do now? Hey.
I said, lift up your hand. I don't have anything. Good day, officers.
Good day to you.
Well, I'm Barrister Mike. Barrister Michael.
Okay. So, who are you looking for?
I got a call that one of my clients was brought here some few minutes ago, so I have come to see him. The name is Tom.
Oh, that one. Nigerian.
Oh, good.
But she just came a few minutes ago, so she's still writing her statement.
Okay.
So once the police are done with her, you may see her.
No, I insist I see my client right now. Yes, he needs me at this point in time.
Now my station, you call the share for me. Eh? Now my station, you call the share for me, Abi?
How?
Barrister, why are you shouting? Is this your office? Are we your workers?
Please don't insult me. I have come here to see my client and not you.
Hey, say you see what we dey suffer for here. All these charge and bail lawyers, they go come. They will want to intimidate us. Hey, I'm a lawyer. Okay? I am a graduate.
I beg your pardon. Who are you referring to as a charge and bail lawyer? Huh? I see. By the time I'm done dealing with two of you, huh, you will know the meaning of charge and bail. Nonsense.
So. The office is that way.
Good.
But hey, come back. First, drop your phone. Okay?
I refuse to surrender my privacy and my telecommunication.
Hey, all this way they talk now, enter here, you come up for here. You don't really concern me. Okay, drop your phone. Choose one. Your client will be your phone. Oh, you
fine, take the phone.
Hey, Bulldog, sit down.
All right. Chief is all set. All right. Yeah, so how can I help you?
Good afternoon, officer. Thank you. I am Barrister Mike. Okay. Yes, and here is my client, Tonti.
I see. So, how can I help you? Yes, now, how can I help you? Do you look like my suspect? Oga, go outside and let the police do their business, please. Go outside.
Officer, you're not doing the right thing. Tonti here has every right to get his counsel. Yes. Moreover, it is his constitutional right, or do you want to deprive him of that? Huh?
Oga.
Officer.
I have told you. Go outside and wait. Let the police do their business. Let me do my work. Osnoboda. All this your grammars, all this your PhD, pack it and put it on your head. Wait for us at the courts. When we get there, we will know who knows the Constitution.
With all due respect, officer, I am doing my job. And so you are. Do you understand me? And the job you do is within the confines and dictates of the law, which stipulates that a defendant or a suspect has the right to a counsel, yes, while detained or arrested.
I don't blame you. Yes? I don't blame you. I blame those that call riffraffs like you to bar. Yes? Do you know how many years I've put into this job? Do you know how long I've been in this work? 20 years.
Officer, listen.
And you of yesterday is here to teach me my job.
The years you put into this job has nothing to do with wisdom of Solomon.
What?
You may have spent 20 years, 50 years, 200 years practicing and learning the wrong thing. Yes, listen to me. No matter how long a vice is practiced, it can never turn to virtue. You understand me?
Barrister Michael, or whatever they call you. As you know, I have been so soft with you. You are busy.
I get you now.
I will show you the hard copy of me. Just wait and see. No,
officer,
wait and see.
We are not quarreling yet. Listen, don't worry, okay? You will not sleep here today, right? Don't worry, I have some money here. Let's go to the counter, okay? I will make sure you leave here today. All right, good. Let's go to the counter. Ooh.
Please switch off your phones as the court is about to sit. Court!
Good morning, gentlemen.
Good morning.
Please mention your cases in order of seniority.
Your Worship, as you can see today. Hello, excuse me. Excuse you what? Isn't it obvious that I'm a sinner? My friend, will you sit down and present my case? Which year were you called to that? I was called to that in 2004. 2004! Wow. But then, Counsel, you shouldn't have been right about this, even if I were to be your judge. I mean, there is record. By the way, I was called to bar in 2000, so I'm obviously a senior. Look, there is no evidence to discipline. Yes! Alright, show us your certificate of college back. Show us! You see, you can't intimidate me because you are my fellow lawyer. Your Worship, as I'm saying. You know, your utterances make me marvel and wonder if truly you were called to bar, as you claim. I mean, you should have known that at the snap of your fingers, you can have the details of every lawyer that you need in Nigeria. Just go to Google and type, find a lawyer, impute the person's name, and every detail concerning the person's color will be shown to you.
Excuse me, gentlemen. This is too early for us to start on this note. Counsel, why are you dressed like this? Is this our dress code? Or are you in your family meeting?
Your Worship. I'm sorry.
Which law school produced you?
Your Worship, Bayelsa.
Bayelsa Law School produced you.
Yes, Your
And you
Worship.
said you were called 2004.
No, Your Worship. In 2014.
Can you step out of the bar? I'm pretty sure Bayelsa Law School was established in 2011. So you cannot be called 2004.
Your Worship, you see, I'm sorry. In my kingdom, 10 years of age is not sometimes a great gap. We are the same age. You see, just that I have my case in another court and I need to hurry up. My wife is pregnant and we are expecting a baby. I need to make ends meet. Please, I'm sorry, Your Worship.
Please, let me sound this as a note of warning. Let this be the last you will do this type of thing in my court. We are not here for child's play. If you do it next time, I will cite you for contempt and possibly report you to LPDC.
I'm sorry.
Registrars, please give him date off record. Counsel, please mention your case.
Your Worship, I'm interested in the number 1 on the criminal cost list.
Registrar, please call number 1 on the criminal cost list.
Charge number A/101C/2024 between Commissioner of Police versus Tom T. Tom T. Please enter the dog.
Registrar, please read the charge.
Mr. Tom T, do you understand English? And I know you. Now, listen to the charges against you. Count 1. That you, Tom T, sometime in the month of August 2020, in Oka, within the jurisdiction of this court, with intent to defraud, did obtain a total sum of 5 million naira from Mr. Charles Ibezie, under the pretense that you are a woman. A presentation you know to be false. You thereby committed an offense contrary to Section 385 of the Criminal Code, Cap 36 reverse law of Anambra State of Nigeria and punishable under Section 380 of same law. Guilty or not guilty?
Mayor.
Count 2. That you, Tom T., sometime in the month of August 2020 in Oka, within the magistrate district of the court, did publicly exhibit amorous relationship by posting on your Instagram page a picture of you kissing a man. A page you know is open to the public and thereby committed an offense contrary to Section 4, subsection 2, and punishable under Section 5, subsection 2 of the Same-Sex Marriage Prohibition Act 2013. Guilty or not guilty?
Mayor.
Count 3. That you, Tom T., on the night of 28 August 2020 in Oka, within the magisterial district of the court, did permit a male person to have a carnal knowledge of you against the order of nature. You thereby committed an offense punishable under Section 196, subsection C of the Criminal Code, Reverse Law of Anambra State, 1991. Guilty or not guilty?
Mayor. I'm not coming down and call. In fact, I come to contact because it's Jim Sikem. No, I'm okay, you want to hear me. I can't be stainless. I want to people. They didn't down.
Your Worship, the defendant pleaded not guilty of all counts.
Your Worship, I respectfully apply for the bail of the defendant on the most liberal terms. This application is predicated on Section 73, subsection 2 of Administration of Criminal Justice Law of Anambra State and Section 36, subsection 5 of the Constitution, 1999 Constitution, as amended, which presumes that the defendant is innocent until a competent court of law proves otherwise. May I refer your worship to the case between EYY versus the state in 1988, 2 Nigerian Weekly Law Report, Part 78602, and Abiola versus Federal Republic of Nigeria, 1995, 1 Nigeria Weekly Law Report, Part 270155. The defendant is a first offender, and as such, he should be allowed to go about his normal business to make ends meet for himself and his aged and sickly mother in the village. Besides, he lives within the jurisdiction of this honorable court, and he already has someone who is ready, a shorty, who is ready to take him on bail and provide him anytime this honorable court needs him.
Okay. Prosecution, any objection?
Yes, Your Worship. We strongly believe that the defendant will jump bail if admitted bail. Your Worship, you're talking about a man here who has the finances and access to funds that can allow him to travel in and out of the country at will. And I am sure that this honorable court will not want to gamble with that. Now, secondly, Your Worship, due to the nature of this case and the effect it has on the younger generation, of which we have lots and lots of them present here in court, I humbly submit that the defendant be remanded in police custody pending the next hearing to serve as a deterrent to others who might want to indulge in such a crime.
Your Worship, it is right law that bail cannot be refused as a form of punishment. The defendant has a reliable surety who is willing to take him on bail and bring him back whenever he is needed in this honorable court of law.
Prosecutor.
Yes, Your Worship.
Is the defendant on police administrative bail?
Yes, Your Worship.
Okay. This is my ruling. I do not see enough reason to deny the defendant bail. Moreover, he is already on police administrative bail. Consequently, the defendant is hereby admitted to bail with a sum of 10 million naira and a surety in the like sum. Surety shall live within the jurisdiction of this court and shall swear to affidavit of means. Surety shall have landed property within the jurisdiction of this court. The defendant, on his own part, must submit his international passport and traveling documents to this court. This matter is hereby adjourned to 13th day of May, 2024 for prosecution to open its case. Registrar.
Yes, Your Worship.
Do we have any other business for today?
No.
Okay. Court will rise.
Court!
Your Worship, subject to the evidence of the court, you are ready to proceed.
Please put in your witness.
Mr. Charles Stephenson, please enter the witness box.
Thank you.
Please, if you know you will give evidence in this matter, please, out of court and out of hearing. Obuni maniga wakebe, you leave them. You go whoever man for them. Are you a Christian, a Muslim, or a traditionalist?
I'm a Christian.
Repeat after me. I, you say your name.
I, Mr. Charles Bezin,
Do solemnly swear
do solemnly swear
that the evidence I shall give in this court today
that the evidence I shall give in this court today
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Witness, please can you tell this court your name, where you live, and what you do for a living?
My name is Mr. Charles Bezin. I live at Ngozika Estate, and I am a businessman.
Witness, do you know the defendant?
Yes.
You don't answer yes. It is either yes, Your Worship, or yes, sir.
Yes, Your Worship.
Witness, please can you tell this honorable court what transpired between you and the defendant on the 6th day of August 2020?
Objection, Your Worship. My colleague here is asking the witness leading questions, which is against Section 221, Subsection 2, Evidence Act.
Your Worship, it is correct that leading questions are not permitted in examination in chief. However, there are exceptions. When the question is an introductory part or relates to the facts in question. See Section 221, Subsection 3 of the same Evidence Act. Your Worship, the dates mentioned here are not in dispute.
Objection overruled.
Witness, please continue.
Yes, Your Worship. On August 6, 2020, we met at the Single Daddies Club, Abakaliki Street, Oka. We exchanged contacts, we introduced ourselves. He told me his name is Tom. She gave me her WhatsApp number, we texted, we were talking and all. Then later on, she gave me her Instagram handle, where I saw a video of her kissing several men.
If you see these pictures, can you recognize them?
Yes, Your Worship.
So to the counsel, defense counsel.
Your Worship, I seek to tender the pictures as exhibit in this case.
Your Worship. I object to the admissibility of this evidence because it is against Section 84 of the Evidence Act, because this evidence right here is a computer-generated evidence and does not align.
Your Worship, what governs admissibility is relevancy. See Section 1 of the Evidence Act, the pictures sought to be tendered here are relevant to this case. However, Your Worship, pictures are not among the documents contemplated within Section 84 of the Evidence Act. With your kind permission, Your Worship, may I read the section as it talks about statements in a document, rather?
Go ahead.
And I read, Section 84. Admissibility of statements in documents produced by computers. In any proceedings, a statement contained, Your Worship, emphasis on statements, contained in a document produced by a computer shall be admissible as evidence of any fact stated in it, of which direct oral evidence will be admissible, if it is shown that the conditions in subsection 2 of this section are satisfied in relation to the statement and the computer in question.
I am minded to admit the pictures as exhibit owing to the fact that from the peripheral, it is a picture of the defendant and relevant to these proceedings. I also agree to the submission of the learned counsel for prosecution that Section 84 is limited to statements in a document. We should always look at the intention of the lawmakers. The mischief the lawmakers want to curb is to avoid people doctoring a document. In the instant case, it is left for the defense to prove that the pictures are not his or that it was doctored. Until then, the pictures are relevant and is hereby admitted in the evidence and marked exhibit P1, P2.
As the court pleases.
As the court pleases.
Witness, please continue.
Thank you, Your Worship. On August 28, 2020, we went out clubbing. We got drunk and we slept together. What I could remember was she rubbed a lubricant on my penis and inserted it into a hole. I ejaculated after some time, and when I did, I realized that it wasn't the hole I expected it to be. It was actually his anus that I inserted my penis into. Then I waited for him to go to sleep so I'll know why he did that. Then I checked and I realized that he is a man posing to be a woman. When he woke up, I confronted him about this situation, and he threatened to blackmail me if, and I say, if I decide to disclose it. The next morning, being 29th August 2020, he asked me for ₦1 million to go to the hospital, which I solemnly refused. And he went all physical on me, even gave me a wound on my stomach, smashed my second phone. Then I picked up my pieces and I immediately ran to the police station afterwards.
And when you brought in the police, what did they do?
The police took my statement and started investigating the matter immediately.
If you see this statement, will you recognize it?
Yes, Your Worship.
Your Worship, I seek to tender the statement of the PW1 as exhibit in this matter.
Defense counsel, any objection?
No, Your Worship.
Statement of the complainant to the police is hereby admitted as exhibit and marked as exhibit P3.
As the court pleases. Witness, is there another thing you want to tell this court on this matter?
No, Your Worship. That's all.
Counsel, cross-examination.
Your Worship, may I take the leave of the court to implore my learned colleague here to cross-examine the witness.
Permission granted.
Witness, you stated in the evidence in chief that you are a businessman. How correct is that?
Yes, Your Worship.
Can you please tell this honorable court the nature of your business?
Objection, Your Worship. The question being asked to the witness here is not the issue, and as such, not relevant.
Your Worship, under cross-examination, the sky is my limit, and I can ask any question to ascertain the veracity of the matter claimed.
Counsel, please, the sky cannot be your limit in this court. Please limit yourself to questions that are relevant in issue. Objection sustained.
You stated in the evidence in chief that you spent over 5 million naira on the defendant. How correct is that, sir?
Very much correct, Your Worship.
So can you tell us how much you earn on a monthly basis?
Is that a question that should be said into court here?
Can you tell this honorable court?
I make over 10 million a month.
What is the nature of your business?
Objection, Your Worship. This question has been asked and overruled.
Objection overruled. The question is relevant in view of the line counsel is towing. Please answer the question.
Yes, Your Worship. I'm into forex trading.
So can you tell this honorable court the meaning of forex trading?
Forex trading involves trading in bitcoins and foreign currencies. That's what it's about.
Tell this court the currency that Ghana, America, and UK use.
With all due respect, Your Worship, I only trade in the American US dollars. Aside that, I don't have any other currency I'm trading in.
Is this business of yours licensed?
Do I need a license to own a business in this country as well? I stay in the comfort of my room with my laptop on my phone, and I make money off it. I don't need to have a license for that.
Are you married?
Yes, Your Worship. I am legally married.
Can you please tell this honorable court how much you give your wife on a monthly basis?
I give my wife 100,000 naira on a monthly basis.
100K? And you give a side chick 5 million naira. I put it to you that you are an irresponsible husband. And that you've come to deceive this honorable court.
Your Worship, this is not a matter of responsible and irresponsible. Of course, I'm a responsible man, but there's a matter at hand here now, and I'm responsible.
Was there any time the defendant forced you to give her money?
No, Your Worship.
So are you trying to tell us that you enjoyed the company and the amorous relationship of this person?
I don't know, Your Worship.
Was there any time she told you she's a woman?
But that's the reason we are here now. He's a man posing to be a lady, extorting money from men to make her nails and buy herself some hair.
That's all for the witness.
Prosecutor, any re-examination?
No, Your Worship.
PW1 is hereby discharged.
Witness, please can you tell this honorable court your name, where you live, and what you do for a living?
My name is Samuel Udoka. I live in Ngozika Estate. I'm a practicing medical doctor. I practice here in Amako Teaching Hospital.
You know the defendant?
Yes, I was on call duty the day police brought him in for some tests, and I conducted some physical examination and some hormonal chromosomal tests and confirmed that he is a man. He has his testicles and penis.
Your Worship, that is all for the witness.
Cross-examination.
Yes, Your Worship. Which school did you say you graduated from?
Nnamdi Azikiwe University, Awka.
I thought as much. And you work with Amako, right? That's good. How many years have you practiced as a medical doctor?
5 years now.
5 years. Perfect. Could you please tell this honorable court if in your 5 years of practice and in your years as a student, of medicine, if you've ever witnessed where a test was carried out on an adult to ascertain if he or she is male or female?
Not really, but it's practicable.
Okay, not really, but it's possible. Okay, that means it is correct to say that the only recognized and sustainable way of ascertaining if someone is male or female is through ultrasound, which is done prenatally.
Yes, you're correct. However, there are still some significant features that makes one a man, which when in doubt, certain tests as the one I conducted can be taken to determine the person's sex.
Fine. I get it. In the course of your interaction with my client, did he at any time tell you that he is the woman?
No, Your Worship.
He didn't. Your Worship, that'll be all for this witness.
Re-examination.
None, Your Worship.
PWT is hereby discharged. Prosecutor, do you have any other witness?
Yes, we do, Your Worship.
Put in your witness.
That is the IPO that investigated this matter.
Put in.
Inspector. Witness, tell us who you are, what you do, and your involvement in this case.
My name is Inspector Sam Odunka. I'm a police officer attached to D7, State CID, Oka, Anambra State. On the 29th of August 2020, a complaint regarding a case of obtaining under false pretense, public display of amorous relationship, and unnatural offense was brought to us against the defendant. The police swung into immediate action and took the complaint's statement, which contained the detailed, or rather the comprehensive details of everything that transpired. I personally visited the defendant's Instagram page where I saw the public display of which one of the petitions has been brought to the Honorable Court as exhibit. I proceeded and went to his home with my officer and requested he come with us back to the command. He came and was granted access to his lawyer. He made his statement, and afterwards, a female police officer was assigned to him for examination, and that was because he claimed to be a woman. After the examination and the whole process, she confirmed that he was a he. Just for clarity's sake, we proceeded to Amako Hospital here in Oka, where he was medically examined just to really ascertain his gender. After the whole process and everything, it was confirmed above every reasonable doubt that he is a male by gender. We proceeded by getting his bank statement, where we saw all the money sent to him by the complainant. It totaled a huge sum of 5,102,000 naira. In the defendant's statement, he denied tyrannically never having sexual intercourse with the complainant or following the complainant to any hotel on that fateful day. We proceeded to the hotel where we got the CCTV footage and confirmed that he tagged along with the complainant to the hotel on that fateful day.
Witness, if you see the video obtained from the CCTV, will you recognize it?
Yeah, I will. Yeah, that's it.
Your Worship, I seek to tender the video obtained from CCTV as an evidence.
Objection, Your Worship. Now, I do not know what my colleague here is trying to tender as an evidence. And besides, he never tendered this ab initio as an evidence.
Counsel, please wait until the CCTV is played. At that point, you can object to it. But for now, the objection is overruled and the CCTV is hereby admitted in exhibit and marked exhibit P5.
As the court pleases.
Your Worship, that's all for this witness.
Cross-examination, please.
Officer Sam, right?
Sam, yeah, Sam.
When the complainant made this complaint, did he furnish you with any kind of money to mobilize you?
No, not at all.
No? Good. So, could you please tell this honorable court how you were able to raise funds that you used to mobilize your men to storm his home, arrested him, went to the hotel to get some CCTV footages and everything?
Funds are being set aside by the police for criminal investigations such as this.
Do you know that to lie under oath is an offense called perjury?
Objection, Your Worship. That question is an opinion question. And the police has not come here as a witness expert. And besides, Your Worship, my learned colleague here wants to intimidate the witness.
Counsel, must you object to everything? Witness, please answer the question. This objection is overruled. Yes or no?
No.
Your Worship, this young man here is a law enforcement agent. And so he should know the law that he is enforcing. You cannot enforce a law that you know nothing about. So he should know that there are consequences to lying to this honorable court. I put it to you that lying under oath is an offense called perjury.
Oh, now I know.
I also put it to you that the complainant furnished you with enough money, which is making you dance to his tunes.
Excuse me. No, that's not true.
Your Worship, that'll be all for now.
Prosecutor, any re-examination?
No, Your Worship.
PW3 is hereby discharged. Gentlemen, I will rise shortly, and when we come back, the defense will open their case. Defense counsel, please put in your witness.
Mr. Conti?
Yes?
Please, could you step into the witness box?
Mr. Tonti, do you understand English or Igbo?
What depending my mood. But anyone, come from Nabiko.
Are you a Christian, a Muslim, or a traditionalist?
A Christian. Okay.
Now repeat after me. I will say your name.
I, Tom T,
Do solemnly swear.
do solemnly swear
That the evidence I shall give in this court.
that the evidence I shall give in this court
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Mr. Damti,
Sir?
please tell this honorable court your name, where you live, and what you do for a living.
I'm from Tom T. I'm in Abakaliki Street. I'm in my business. I make content.
He said his name is Conti. He lives in Abakaliki Street. He's a businessman and a content creator.
Damti.
Oh, Tagun, sir.
Bit by bit. Could you tell this honorable court what transpired between you and the complainant?
Okay. Dika anyị si na-aga amata m ya n'ime club.
He met him in a club.
Amata m ya n'ime club. Ya nwa nye m nọmba ya. Ya nwa n'akwa m nke ya o. M na-ebido diwa na mma.
They exchanged contacts.
Ịghọtago na kata ebidokwa diwa na mma ebido diwa na mma na-aga. Ọ sị m na ọ fụrụ m n'anya na m na-achaba ya n'anya.
They started being friends, and then he told him that he loves him.
Ịghọtago anakwa m ya ego. Ụkwa ya nọkọtara o ji aka na-esendịrị m ego. Ịghọtago nwa n'ụdị ego na-adị mkpakọ na nche kọd na-adịgodo obere ụcha ka nwa ihe na-aghọta. Ya ka o rikwe one day ofu ụbọchị anyị gacha klọb nata. Ya bụ nwoke sị na o nwe ka arụ si emesi ya.
Registrar, please interpret.
And then he started sending her money, or him rather, money, unconditionally, without him or her asking for it. So, one day, him or her followed the complaint.
Dịka onye si na-aga nsị azụkwa n'ike kwe na ọghọta nsị azụkwa n'ike ụla buru m amazụkwa mgbe o ji si n'azụ ịghọtago tinye nya bụ ife n'ife n'azụ ma ana m alalụkwa ụla mgbe ya na-eme o.
And then when they were sleeping, the complaint injected something into her by force.
So o mechaa that day ọ nyụkwara o nyi na ọ nyụkwara ọ nyụrụ that boy nyụrụ any day kwa ya ọ nyụrụ ọkwa na ọta.
Ejaculated. So after that day, both of them started having misunderstanding.
Tinye ebe ọsọ ọ mechaa that day m na-abụ nwa okwu ihe ọzọ na fusikwa ndị polisi njikwa na mmadụ ego by force di na nwoke ibe m ya na ihe ndị ọzọ dịcha manara aghọta sokwe ya o ọ gwụchagwụkwa.
So one day, while he was at home resting, the police officers came and arrested him, saying that he collected or he obtained money from someone under a false pretense.
It's a false pretense.
Wow. Interesting. Tom T.
Sir?
Please tell this honorable court if you at any time told the complainant or implied to him that you were a woman.
Ha! Mbao. Anayim. Mbakwa. Okay, my off na room. So I am with awful.
His answer is no.
Your worship, that'll be all for the defendant.
Cross-examination.
Mr. Tom T.
Daddy. Oh, sir.
Mr. Tom T, you said you can't read or write in English language.
You see?
Registrar, please translate where necessary.
Mom, here now. What depends on the mood? Depending on my mood. Sure you understand.
He said it's depending on his mood.
Who owns the Instagram page, Tom T. The Sharp?
The way Instagram Naza Tom T. The Sharp.
Oh, Mua. I'm a Indian and about any actor acting. I make contact. You tago. If you pass part time sometimes, I need to.
He said he's a content creator, so he does those things sometimes because of content.
Mm-hmm.
Tom T, look at this exhibit. Are you the one in this picture?
Oh, my goodness. Oh, Mua.
He said he's the one.
Hey.
Counsel, what do you intend to do with this?
I'm getting somewhere.
Until then.
Mr. Tom T.
Sir.
Did you at any point in time go to the hotel with the complainant?
It's again.
A Gago hotel. Gina the complainant at Gago hotel.
Gina complainant.
Only put a court. Gina Gago hotel.
Amam, I was in Biko.
Mr. Tom T, yes or no?
I asked Mama Rom.
He said he doesn't know.
So you don't know whether you have been to any hotel with the complainant?
Daddy, I was remember because of we sometimes I had to why I go before Queen Water. So Amarom, that's it.
That's all, Your Worship.
Defense counsel, any re-examination?
No, Your Worship.
This is my judgment. The defendant was charged to this court on a 3-count charge to it. 1, obtaining the sum of 5 million naira under false pretense, contrary to Section 385 of the Criminal Code, Cap 36, Revised Laws of Anambra State, 1991, and punishable under Section 380 of the same law. 2, public exhibition of amorous relationship, contrary to Section 4, Sub 2 of Same-Sex Marriage Prohibition Act, 2015, and punishable under Section 5, Sub 2 of the same law. 3, unnatural offenses, to with having carnal knowledge of a person against the order of nature, punishable under Section 196, Sub C of the Criminal Code Laws of Anambra State. Before I proceed with this judgment, it is important I observe that Count 2 is an offense under the federal law and by provision of Section 6 of Same-Sex Marriage Prohibition Act 2013. This court is robbed of the jurisdiction to entertain or deal with it. Accordingly, I hereby strike out the said count from this charge. In criminal matters, like the instant case, prosecution is required to prove its case beyond reasonable doubt. See Section 138, Sub 1 of the Evidence Act 2023. Also, the case of Okore against the state, 1998, 14 Nigeria Weekly Law Report, Part 584. The prosecution in the discharge of its duty called 3 witnesses, and these are their evidence. PW1 is one Mr. Charles Ibezim, who incidentally is the nominal complainant in this case. It is his evidence that he met the defendant sometime in August 2020 in a nightclub at Abakaliki Street, Awka, Anambra State. Both of them exchanged contacts, including Instagram handles, and from there started dating. A week later, they went out for clubbing and came back in the state of amnesia due to the alcohol they consumed in the club. While inside the room, one thing led to the other, and they had anal sex. According to him, it was when he released that he realized it was inside the defendant's anus he inserted his penis. It was at this point he became inquisitive to know why the defendant inserted the complainant's dick inside his anus instead of vagina. This inquisitiveness led him to harass the defendant while he was asleep, and then discovered the defendant is not a she, but a he. In the morning, he confronted the defendant with this fact, which the defendant owned up to. The defendant, instead of being sober and apologetic, threatened to blackmail the complainant if he discloses this fact to anyone. The defendant did not stop at this, but also demanded ₦1 million for him to use and go to the hospital. This demand, the complainant declined. This culminated into the seizure of the complainant's phone by the defendant. This is how the complainant brought in police in this matter. PW1 in his evidence further stated that he made a statement to the police in the course of investigation, and the statement was tendered in this court as Exhibit P1. PW1, after his evidence in chief, was duly and fully cross-examined that same day and also discharged. PW2. PW2 is one Dr. Samuel Udoka, who is a medical doctor working with Amak Teaching Hospital, Oka. He stated in his evidence in chief that he was on call the day the defendant was brought by the police for medical examination to ascertain the real sex or gender of the defendant. According to him, some physical introspection and chromosomal tests were carried out, which proved the defendant to be a male, with his testicles and penis intact. Again, this witness was also cross-examined and later discharged. PW3 is the investigating police officer, the IPO. Basically, he testified that when the matter was assigned to him, he went to the house of the defendant in company of one of his colleagues to arrest the defendant. He stated that he observed the Miranda rights of the defendant, and the defendant volunteered his statement in the presence of his lawyer. He further stated that he took the defendant to the hospital for medical examination. He obtained the account statement of the defendant from the bank and also CCTV from the hotel. The account statement and CCTV were tendered as exhibit in this court. At the close of his evidence in chief, PW3 was cross-examined and later discharged. With this, prosecution closed its case and defense opened. The defense counsel, in defending this charge, called one witness. That is the defendant, who is the DW1. The DW1 in his evidence testified that he met the complainant in the club and from there entered into a relationship with him. He stated in his evidence that he is just a cross-dresser and never stated or told the complainant that he is a woman. He gave evidence to the fact that the complainant sends him money at times. He corroborated the evidence of PW1 that they went to club on the 9th of 28th day of August 2020 and came back drunk. He further stated when they came back, the complainant asked for sex, which he replied him, "Zukwani ike," that is, rest. But at the end, they had anal sex. The defendant was fully cross-examined and defense counsel closed his case. At the close of defendant's case, the court ordered for written address of the parties, which was done and adopted. I have carefully examined the evidence of parties, shrewdly observed their demeanor, the demeanor of the witnesses, painstakingly perused through the exhibits, and noted succinctly the submission of learned counsel for both parties. I must say, without hesitation, that this case is one of those cases we all should be ashamed of as human beings, more especially as Christians. It reminds us again on the failure of parents and families, which Article 18 of African Charter of Human and People's Rights states that families is the basic unit of every society. I will say more in the course of this judgment. Count 1 of the charge deals with obtaining under false pretense, contrary to Section 386 of the Criminal Code Laws of Anambra State. This offense is popularly known as 419 because it is codified or contained under Section 419 of the Criminal Code Act, Laws of the Federal Republic of Nigeria. For clarity purposes, Section 385 defines false pretense to mean any representation made by words, writing, or conduct of a matter of fact, either past or present, which representation is false, in fact, and which the person making it knows to be false or does not believe to be true, is a false pretense. Under cross-examination, the complainant admitted that there was no time the defendant told him he was a woman. He also admitted to the fact that the defendant never forced him to send money to him. Question: was there a time he told you she's a woman? Answer: no, Your Worship. But she dresses and poses as one and even collects money from me to make her hairs and nails. Question: was there any time the defendant forced you to give him money? Answer: no, Your Worship. I agree with learned counsel for the defendant that facts admitted need not to be proved. The complainant admitted that the defendant never forced him to give him money and never told him that he's a woman. However, the question that begs for answer is, what does the defendant want to achieve by dressing or posing like a woman? Or has the defendant conducted himself in a way or manner every right-thinking person will assume or conclude he is a woman? I am minded to answer these questions in the affirmative. The defendant, having the option of buying male clothes and apparels, opted to buy women wares and dress like one. Leaves more to be imagined. He has by conduct misrepresented his true identity for the reason not far-fetched, that people will see him as a woman and accord to him all benefits that accrues to women, including but not limited to giving and taking. More so, where the complainant does not know him ab initio. This is the true test of the saying, you are addressed the way you dress. The hood does not make a monk, which simply means cuculus non facit monachum, is of no moment. A monk is known by the hood, especially to someone who doesn't know you are a monk. Assuming this position is wrong, then it behoves on the defendant to tell the complainant that he is not a monk. He was busy enjoying the benefits and privileges extended to women, collecting and obtaining millions from the complainant, knowing that the complainant is unaware of his true identity. I shall in the course of this judgment say more on this, on the profligacy, prodigality, and promiscuity of the complainant. Count 3, now count 2, having struck out count 2, deals with most disdainful, despicable, and obnoxious practice of reordering nature. Unnatural offenses, particularly anal sex, which is synonymous to sodomy. Sodomy, according to Black's Law Dictionary, 8th edition, means oral or anal copulation between humans, especially those of the same sex. It could also be oral or anal copulation between humans and animals, which is usually called bestiality. A person who indulges in sodomy is called a sodomite. This word is traceable to the story of the destruction of Sodom and Gomorrah in Genesis 18, verse 16. In other words, sodomy is capable of destroying the entire society. No wonder Justice Oputa of the blessed memory in the celebrated case of Godwin Josiah against State, 1985, One Nigeria Weekly Law Report, 125 at page 144, said, and I quote, "Justice is not a one-way traffic. It is not justice for the appellant only. Justice is not only a two-way traffic. It is really a three-way traffic. Justice for the appellant accused of a heinous crime of murder. Justice for the deceased whose blood is crying to heaven for vengeance. And finally, justice for the society at large, the society whose norms and values have been desecrated and broken by the criminal act complained of. In the instant case, the complainant, who is a married man, went to a nightclub and his inordinate desire and promiscuity got him attracted to an artificial woman. When there are lots of beautiful and natural women in the club, according to him, he earns over 10 million naira monthly, but gives his wife a peanut of 100,000 monthly. And within a space of 2 weeks, lavished over 5 million naira on an unknown side chick who never contributed anything towards the growth of his business or development. Unfortunately, the side chick, who is the defendant in this case, pretends to be a woman in order to get from men what women get, but could not give what women give to men. In a crazy attempt to do so, had landed the defendant in the dock and the complainant in the witness box. Both parties are in agreement that they had anal sex. The difference is that the defendant stated he was drunk and had to sleep. I do not want to believe the defendant when he knew his way from the club down to the hotel room. More so when he testified on oath that the complainant asked for sex and he replied, Zukwanike. The defendant had ample opportunity of disclosing his real identity to the complainant, or outrightly say no to the demand of the complainant. The principle of law is qui non improbat approbat. He who does not disapprove approves. See also the case of R against Abeg, 1948, 173, 33 CR. In any case, the defendant is charged under section 196 sub C, which provides any person who permits a male person to have carnal knowledge of him or her against the order of nature is guilty of a felony. This case calls to mind the words of Nikitobi, Justice of the Supreme Court as he then was. In a similar case, in Major Bello Mogaji against the Nigerian Army, SC 204, 2004, NGSC 11, where Nikitobi said, I think I have taken half the issue raised by Leonard Senior Advocate. I'm quoting him. What the appellant decided to do was to denation in his craze for immoral amorphous satisfaction. By his conduct, the appellant reordered God's creation. Has he got the power to do that? No. No human being, whether in the military or not, has the power to reorder nature, God's creation. After all, we are not talking of fighting a war. By his conduct, the appellant has brought shame to himself, although a bit of the dent is on the army. I am not prepared to hold the force guilty of the conduct of the appellant. The army did not ask him to commit this heinous and atrocious offense. He is a terrible criminal, and he is alone, clearly alone. Reading further the lead judgment, Nikitobi said, this case brings to the open the problem of poverty in our society. Not just poverty, but abject poverty. Parents should try as much as possible to provide for the needs of their children. And when I say this, I am not unaware or oblivious of the fact that some children are not satisfied even if their parents supply all their needs because of their insatiable, growing and glowing gluttony for more and more, like Oliver Twist of the literary firm. From the foregoing wisdom of my Lord Nikitobi, I wish to state that nothing can best describe the action and inaction of the complainant in this case than utterly irresponsible husband and father who prefers to spend and spoil others at the expense of his family. I wonder why he was not charged along with the defendant. However, I do know that the state has discretionary powers on whom to charge. It is the position of law that he who sins when drunk shall be punished when sober. Qui peccat ebrus luet sobrius. I am convinced that the defendant, from all intent and purposes, falsely represented himself in the guise to obtain the sum of 5 million from the complainant. Accordingly, I find the defendant guilty as charged in count 1. In the same manner, I am convinced he consented or condoned the anal sex he had with the complainant. Accordingly, I find him guilty as charged as per count 2. Any allocutus?
Your Worship, my client is an orphaned child. In fact, an only child. The father is late, the mother is late, and he has an aged and sickly grandmother in the village who is dependent on him. He's still a young man that can go out there and make money and take care of his family, take care of himself and his family. So I ask this honorable court that you please show leniency in your judgment.
I've listened to the submission of counsel for the defense, and in view of the fact that the defendant has an aged mother he is taking care of, I am minded to order for restitution in count 1 in lieu of imprisonment. I hereby order the defendant to restitute the sum of 5 million naira. This money is to be paid to the wife of the complainant by the defendant. As for count 2, in Genesis chapter 18, verse 22, Abraham pleaded for leniency in favor of Sodom and Gomorrah. Unfortunately, none was found. Accordingly, I have viewed the demeanor of the complainant, especially in regard to count 2. I see no remorse from the defendant. I hereby sentence him to 14 years imprisonment without option of fine.
As the court places